Thank you. The accused may be seated. Thank you. Good. Thank you, Ms. Ludwig.
Thank you, my lord. With your indulgence, I'm calling the matter of State versus Musa Kekana and 4 others, case number SS 98 of 2025. My lord, the matter is placed before your lordship for trial today. I'm appearing on behalf of the state together with Advocate Katie Ndubane.
As the court pleases, thank you, my lord. I confirm my appearance on behalf of accused number 1 in the proceedings. I also confirm that my appearance is on instructions of Strauss de Waal attorneys. Mr. Strauss is also present in court.
Thank you, Mr. Kissing.
May it please the court, my lord, I confirm my appearance on behalf of accused number 2.
Thank you.
May it please the court, my lord. I'm an Infadelieva advocate appearing on behalf of accused number 3 and 4 in this matter. I'm instructed by Maluleke Inc. Mr. Maluleke is present in court and seated next to me. May it please the court.
Excellent. Thank you for that.
As the court pleases, my lord, I'm Advocate T. Chauke, representing accused number 5, instructed by MD attorneys.
Good. Thank you so much. Good.
Thank you, my lord.
Mr. Leroux, the matter is ready to proceed. I'm given to understand. Am I correct?
That is correct, sir, my lord. My lord, before I proceed with putting the charges, I would like to draw the court's attention. There's a green exhibit file in front of your lordship.
Yes.
What the court will find in there is firstly the direction for centralization, which was issued by the National Director on the 23rd of October 2025, and that specifically relates to, my lord, counts 1 to 8 and counts 19 to 25 of the indictment, because those 2 matters falls then under the jurisdiction of the Pretoria Division.
Okay. Yes. Is there anything else?
Thank you, my lord. It should be the original. I just want the court to make sure of that. Last we checked, it was indeed the original.
Yes, I have it.
Yes. So, my lord, also just to bring this to the court's attention, there was a previous indictment, but that indictment was then replaced by an amended indictment during the pre-trial proceedings. The exact date I can't recall now, but I think it was sometime in March of this year. So, just to be alive to that, I don't want the court to be stuck with an old indictment. So
Okay,
the
give me a
latest
second.
indictment is also included in your green exhibit file.
Yes.
What the court will also find there is an updated list of witnesses. My
So
lord,
just to understand, we're on the same page with, together with counsel. You have got the indictment comprises of 25 counts.
that is correct, sir, my lord.
And is that the indictment that has been signed by J.M. Serepo?
That is correct. That's the one,
Is
my
that the
lord.
correct indictment?
Yes.
Counsel, are we in agreement that's the indictment that we're working off?
Yes,
Mr. Kissing?
from my side, I confirm that, my lord.
Mr. Ruvia?
Going agreement, thank you.
Good, thank you. you, Ms. Little.
Then, finally, my lord, the court will also find in the file an updated list of state witnesses. So, during trial preparation, we've realized that there's some witnesses whose names appear twice on the list. That was removed, and some witnesses' names did not appear on the list. So this is an updated list of witnesses. So this is the list that I've also provided to the defense this morning, and this is the list that we will work from when we refer to witnesses.
Good.
Thank you. So, my lord, I'm ready to put the charges.
I think before we put the charges, don't you believe that we should be dealing with the aspect that was dealt with in chambers?
As the court pleases, my lord.
This is case number SS 98/2025 in the matter of the state versus Musa Kekana et al. The matter, as the court understands it, is set down for trial for a period of 30 days, as indicated on the court roll. This morning, before the matter was called now, the court, which matters were dealt with in chambers, essentially the matter that was dealt with in chambers was simply to ensure or to inquire if the trial was ready to proceed, the availability of counsel during the days of the matter being set down, and other general housekeeping issues that needed to be dealt with. It emerged during the course of the discussion that Mr. Rian Hussain, instructed by Joe Strauss attorneys, who represents accused number 1, Mr. Musa Kekana, that he has indicated to this court his non-availability on the 5th and 6th of August 2026, as well as for the period the 11th to the 28th of August 2026, on the basis that he has other matters set down during that period of time. The court then allowed counsel to communicate with their respective clients in order to obtain further instructions relating to this particular challenge faced by counsel for accused number 1 in relation to the dates as mentioned by this court. Upon resumption in chambers, counsel for accused number 3 and 4 had indicated that her instructions were that the matter was set down by my brother, acting judge Karam, for the period 20th of July, Monday 20th of July 2026, up until Friday the 18th day of September 2026, being the period for the entire term, and as I understand it, to be approximately, I think, 9 weeks. That proposition, as the court understood it, is different to what is in fact on the court roll, wherein the court roll indicates the matter is set down for 6 weeks, and essentially which equates to a period of 30 days. Without further debating the issue, I believe it's important, in order for the smooth running of this particular trial and without any interlocutory challenges being faced in the middle of evidence, the court is of the view that this issue needs to be dealt with at the outset before the charges are put to the accused and before the matter proceeds any further. In the circumstances, Mr. Hussain, I now have been advised in chambers that you intend bringing an application and addressing this court in relation to this aspect on the basis that, as I understand, it is opposed by accused number 3 and 4.
As court pleases, thank you, my lord. My lord, I confirm what your lordship has placed on the record, what transpired during discussions in your chambers. My lord, I've also confirm that on behalf of accused number 1 that we are ready to proceed with the trial. However, as you quite correctly pointed out, there are certain challenges that I have with regards to my availability between the 11th of August until the 28th of August. Now, in order for you to make a prompt decision, I respectfully submit that I need to give you a little bit of background. That on the 26th of February, I appeared in this particular court before your brother, Judge Karam, AJ, on instructions of Mashele attorneys. On that particular date, I have placed my unavailability on record, and with that understanding, the trial date was arranged. My Lord, it is so that in between, my instructions were not confirmed by Mashele attorneys, and I have conveyed my position to my learned friend, Advocate Leroux, on behalf of the state. This was in turn conveyed to the Honourable Court, Karam AJ, on the next occasion, and the understanding was, this was now in my absence, as I took it that my mandate was terminated, that Mashele attorneys will conduct the trial. It is my understanding, and from what I understand from my learned friends, on behalf of the state as well as the co-accused, that in my absence, then Karam AJ made an order that the matter will proceed from the 20th of July until conclusion of the trial. My Lord, I'm instructed that Mashele attorney's mandate was terminated, and my instructing attorney, Mr. Strauss, from Strauss de Waal attorneys, came on record, and I was duly so instructed for purposes of this trial. However, my unavailability still remained on the 5th and the 6th of August, as well as the 11th of August until the 28th of August. I can place on record that we found a way to proceed on the 5th and the 6th of August, as Mr. Strauss will stand in for me during those 2 days. However, for the 11th until the 28th of August, it is my instructions that I should be present during the trial representing accused number 1. Now, I respectfully submit that this order by your learned brother was made in the absence of accused number 1's current legal team. I respectfully place on record that accused number 1's current legal team bear instructions for the period in accordance with my availability, excluding the period 11 August until the 28th of August. I've placed on record that I have another trial in the Gauteng High Court within the Pretoria jurisdiction, which was in actual fact postponed before this matter was set down for trial. Hence, bringing it to your learned brother's attention on the 26th of February. I submit that the decision to set the matter down for a specific period, and I submit this with respect, my Lord, is interlocutory in nature. I submit that an order made by your learned brother for purposes of a period that the matter should be set down and proceed with is interlocutory in nature, can be reconsidered, and you are not bound by his order. My Lord, it is so that my client in the Benoni matter is also in custody. It is also so that likewise accused number 1 and the remainder of the accused in causa, accused in the Benoni matter, also has constitutional rights and a right to a speedy trial. I have committed to that particular matter. I've already consulted with the accused in that particular matter, and it would then, at this early advanced stage, be my application that this matter stand down for the period 11 August until the 28th of August. I will then be available again from the 31st of August until the 18th of September. I think what is, and I submit this with respect, what is of significance is the fact that the period that I am available to proceed with this trial is in actual fact 30 days. What is of further significance is your Lordship's utterances that this matter is set down for a period of 30 days. With respect, I submit that from the onset, from my first appearance in this matter, and upon arrangement of the trial date, and I think what I've placed on record, my learned friend for the state can confirm. And I think what my learned friend for accused number 2 can also confirm what I've placed on record on the 26th of February 2026 upon my first appearance. I submit that it can never be in the interest of justice that for a period of 1 day short of 3 weeks that Mr. Strauss, who is not the leading counsel and who will not be present during all the days in court, that the matter continues, stands in whilst I'm busy with another matter. That will not serve accused number 1's best interest, and most probably might infringe his right to a fair trial. I plead to this honourable court to grant my request for the reasons advanced, as it pleases your Lordship. Unless there's anything else.
Thank you so much, Mr.
Thank you.
Mr. Grovier,
May it please the
can
court,
I
my
hear
lord.
you in relation to the application brought by Mr. Gissen?
My lord, I have no objection to the request for the matter to stand down for the specific dates of the 11th till the 28th of August, on the basis that Advocate Gissen made it very clear at the outset when we arranged the date of today that he will not be available during those days. May it please the court.
Ms. van Geerden, thank you.
May it
Ms.
please,
van Heerden?
may it please the court, my lord. My lord, I first wishes to place the following on record.
So
That-
you're going to make your submissions in respect of both accused number 3 and 4.
Both accused 3 and 4, my lord.
you.
First of all, my lord, my learned friend acting for accused number 1 has one thing wrong. That was not a suggestion made by your learned brother Karam, whether he's acting or not. He's still a judge of this division. He made a court order. And I can do no better when it comes to court orders. But before I go there, maybe I just want to place the following on record. Up till this morning, nobody informed either myself or my attorney of the fact that this application is going to commence. Now, having dealt with the fact that it's a court order, and I respectfully submit, I was present, so were most of the press present in court today on the days when this issue was ventilated before your learned brother. He made a court order. I can do no better when it comes to the validity of court orders than to quote...
Can I just ask you, can you just assist me?
Yes.
When Karam AJ made a court order, it is my understanding that that court order binds this court here, that I have to make myself available also for the entire period, 20th of July 2026 up until Friday the 18th of September.
Yes, my lord. If your lordship would please
Is that your understanding?
Yes, my lord. Will you please permit me to finish my submissions to you? I would gladly, when I finished my submissions, deal with any questions your lordship has of me. A court order is a court order, my lord. And with your lordship's experience, I respectfully submit your lordship should know that that court order stands until such time as an application is brought, a substantive application, to set aside such court order. Now, to set aside a court order, this is trite law. You can set aside it for a variety of reasons, and I did not hear any of those reasons forthcoming. It's further trite law if you wish to set aside the court order that you bring a substantive application. Now, why do we have court orders? In the Zuma matter, the very last matter that the Zondo Commission dealt with, Justice Sisi Kampepe, who delivered the judgment in that matter, said the following, and I refer your lordship to paragraph 26 of her judgment. She said, court orders are effective only when their enforcement is assured. Once court orders are disobeyed without consequence and enforcement is compromised, the importance of the courts and the judicial authority must surely follow. Effective enforcement to protect the Constitution earns trust and respect for the courts. This reciprocity between the courts and the public is needed to encourage compliance and progressive common constitutional purposes. Now, my lord, there is no arguments, and there can be no argument that that's a court order. That court order will stand until such time as an application is brought to set aside that court order for any of the recognized reasons that strike in law. Now, my understanding is, my lord, and until such time as somebody explains it differently to me, that the person that compiles the roll is somebody that sits at the office of the DPP. I can only assume the reason why your lordship has a court roll that sets for 30 days is that there must have been some communication or miscommunication with whoever the roll planner was. Because the court order and the order that was repeated time and again by Mr. Justice Karam in this court was that this matter will commence today and continue uninterrupted until such time as it is completed. Now, on the 30th of June 2026, I was not present in court. That was the day when Mr. Joe Strauss appeared for the first time in this court. My instructing attorney sitting next to me was present in court on that particular day. And my instructions is that Mr. Justice Karam made it patently clear to Mr. Strauss what the court order was. So already on the 30th of June 2026, Mr. Strauss knew exactly what the court order said. if for some reason he or his client or counsel was dissatisfied with that court order, it took them 3 to bring a substantive application at that point in time and request that the court order be rescinded for any of the well-established reasons in case law, or that that court order be set aside. Yet they did not do that. And I respectfully submit, my Lord, again, as the law is straight, that until such time as a substantive application is placed before your Lordship, setting out cogent reasons, dealing with the various factors that is there in common law, giving us an opportunity to properly respond, that court order stands, and your Lordship is bound by that court order. That is the law. We do not unnecessarily want to be obstructive and not understanding a colleague who booked himself in a different matter and has now come in this matter. I think when I was a young counsel, Elof JP made a ruling, and I can't recall it, I think it's Van Heerden and others versus the Office of the Attorney General, where he, at that stage being the Judge President, made it very clear that if you accept a brief, you do it so, knowing that you are available to continue with that particular matter. I'm not without sympathy for my learned friend and for his predicament, but unfortunately the position is that this matter is set down for trial, including on the days that he says he's unavailable to hear the matter. When that court order was made, my learned friends, all sitting to the right of me, were present in court. They all agreed with the court order that the matter will start, will commence, and continue until finalized. What we have done in the meantime, my Lord, if your Lordship wishes to read those orders for yourself, I respectfully submit, as an officer of the court, you can accept my word for it. We have gone and requested that the transcripts be urgently typed so that it can be placed before your Lordship. In the interim, respectfully submitting that there is a court order in place, that your Lordship is bound by that court order, I submit at this point in time this matter must proceed on the days allocated. As I said, the law provides ample authority and opportunity, if you're not happy with the court order, how you deal with it. So my learned friend, it stands him free at any given time, having regard to the legal and right principles, to deal with the court order as it stands. We object, we say the matter must proceed on the days in question. We say that your Lordship has no choice, respectfully, because it is a court order. It's not just some throwaway comment made or an obiter expression by Mr. Justice Carey. He made a court order. May it please.
Mr. Choke.
As the court pleases, my Lord, in respect of accused number 5, we are leaving the issues in the capable hands of this honorable court.
Do you have any objection to the application?
We do not have an objection, as the court pleases.
Ms. Leroux, ma'am. Can I hear you? Thank you.
In principle, do not have an objection. I can add, my lord, that I can confirm what Mr. Kisson conveyed to this court.
I, in fact, went through my notes and I found a short note that I made there on the side indicating the dates that he already then placed on record. So, and I am aware that Mr. Kisson...
So, if I understand you, are you then saying as far back as what, June or February?
Yes.
That the parties were already informed that the matter is not going to proceed in that period?
That
Is
was...
that what you are saying?
I've got a note on that.
February or in June?
That was in February, my lord.
February.
So at that stage, that was the note that I've made, and that's on the one aspect. The second aspect, my lord, is my understanding was that if the trial would continue, it would continue for this term. I agree with my learned friend there, and on my calculation, we have 30 days, which was allocated as an estimate for the duration of the trial, as the court pleaded.
Sorry, 1 moment. Mr. Rivers says you have no objection.
I have no objection.
My lord, with your lordship's permission, if you have any doubt as to the existence of a valid court order, I'm going to ask your lordship, to which you are bound, I'm going to ask your lordship that the matter then, this particular issue is held over. I do not believe we should further spend undue time on it today. There's other matters that your lordship is seized with in this trial that you can continue with. And we present your lordship with the transcripts, where your lordship can see for yourself that the issue about the unavailability of Mr. Gisson was ventilated before Mr. Justice Curran, and notwithstanding the arguments that he made.
When was this, in June or in February?
My lord, it was throughout. There was
No,
about...
but just give me the date.
if your lordship will have to give me a second so I can give you
No
the
problem.
dates.
Just give me the date.
I will give you... So I know it was argued on the 30th of June.
30th of June.
Yes, it was argued then. That was the date when Mr. Strauss first came on record. It was again ventilated on that day, his non-availability.
30th of June, eh? Yeah.
And each and every appearance from the first date, the issue was raised time and time again. Mr. Gisson is not available. The matter can't continue by various attorneys appearing or counsel appearing. Mr. Justice Curran had due regard to the arguments that were presented to him. And notwithstanding the submissions placed before him, he made it clear that the court order is there, the court order should be obeyed. He's made his court order, and the parties are to adhere to the court order. This was said on each and every, your lordship has in front of you the court file. You would notice that there's a number of dates on which we appeared. On each of those dates, I inform your lordship, as an officer of the court, this issue of Mr. Gisson's non-availability was argued. It was Justice Curran had regard to those issues. He was alive to it. He heard the arguments, and nothing was persuasive enough for him to change his court order at that point in time.
On the 30th
As long
of June,
as
on the 30th day of June 2025.
26.
26.
Yes.
This is the order of the court, where Karam AJ. It reads as follows. The matter is postponed for trial to 20 July 2026. Number 2. The NDPP is ordered to respond to the reps made to it on behalf of accused number 5 by close of business on 10 July 2026. Accused number 1 to 3 in custody, accused number 4 and 5 on bail, extended and warned.
Then the date is incorrect. My attorney gave me the date. If your lordship would
Let's
give...
go to the 17th of June 2026. Karam AJ. So now we're going backward, okay?
Yes, my lord.
By agreement, matter is postponed to 30th of June 2026 to confirm funding by accused 1 and status of reps by accused number 5, to which no response has been received by NDPP. Accused 1 to 3 in custody, accused 4 and 5 on bail, extended and warned, accused 5 excused from attending. That was on the 17th of June. 2 days before that, on the 15th of June, Karam AJ, by agreement, matter is postponed to the 17th of June 2026 for accused 1's attorney to appear. Mr. Radebe is given leave to withdraw, gives court undertaking to hand to accused 1's attorney all documentation in his possession. J7 endorsed that accused 2 will receive medical attention at the prison in respect of his eyes. Accused 1, 2 and 3 in custody, accused 4 on bail and extended, accused on bail and extended to trial date, accused 5. That was the 15th of June. 26th of February, I think that's where we'll start from. It says, please turn over. Let's see what it says to me. 26th of June, I just see it says turn over. I don't see anything else.
My lord,
Okay,
that...
hold on a second. Just want to see here. It says here, on the 26th of February, Karam AJ, the indictment is amended. 2, the trial date remains the 20th of July 2026, and to proceed uninterruptedly. 3, matter is postponed to 15th of June and possibly 17th for application, blah, blah, blah. But in terms of the order, does it say here that the trial date remains 20th of July and to proceed until uninterruptedly, and the trial judge is ordered to continue on those days?
My lord, then I suggest, if it's not written on there, that we provide your lordship, because I was in court, my instructing attorney was in court, that your lordship then reads yourself what was ordered by Mr. Justice Karam, what was before him. I think it's the only way that your lordship can be au fait or properly au fait with all the
Thank
facts.
you. Let's say for one moment this court accepts your ipse dixit,
Yes.
that the learned judge ordered that the matter must run uninterruptedly from the 20th of July up until the Friday the 18th of September. Now there's an application before this court. Is this court not allowed to deal with the application before it?
My lord, your lordship can deal with the application before you, but I'm respectfully submitting to your lordship this issue of Mr. Gissing's availability was dealt with at
No, but
all.
let's just say for one moment, I accept that there's an order by my brother that you do not have to produce the transcripts. You do not have to produce the court order. This court accepts it, will accept your ipse dixit. So let's move from that perspective.
But look-
Are you then saying that despite the fact that this court is now faced with an application before it today, it cannot entertain the application?
Your lordship can entertain the application, but if that is the way your lordship is leaning in this matter, then I'm going to ask that the matter stand down so that my client, we can prepare a substantive answer to your lordship under oath as to why this matter should not be postponed on those particular days, which deals with my client's prejudice in this matter, if the matter is to stand down, to deal with the submissions that were made before, to deal with the fact that counsel, meaning myself and my attorney, had to turn away work and work that I was already allocated for this period, and it was placed on record, that that work was passed on to other counsel to do. And also to deal with the relevant case law about availability when you ask, at this point, when you take on a brief, what the law says pertaining to that particular issue. So if your Lordship is so inclined to deal with it in that matter, then I ask the,
anything further, Ms.
I ask the opportunity that we then respond to that application substantively. May I please?
Thank you, I've heard you. This is case number SS98 of State 2025 in the matter of State versus Musa Kekana et al. The matter is set down for trial today, Monday the 20th of July 2026, and it is undisputed, as per the court roll, that this matter is set down for 30 days for term 3 2026. At the commencement of the proceedings, Mr. Hassan, who appears on behalf of accused number 1, duly instructed by Mr. Strauss from Strauss Duval Attorneys, brings an application to this court for the matter to be paused during the period Tuesday the 11th of August 2026 up until Friday the 28th day of August 2026. In support of his application from the bar, Mr. Hassan indicates that as at the time when the dates were in fact set down, he had made it abundantly clear that he was not going to be available on the 5th and 6th of August 2026, and in addition thereto, not available to proceed during the period the 11th to the 28th of August 2026. In support of his non-availability, Mr. Hassan had indicated, as he did to the pre-trial court per Karam AJ, as well as today, that he is seized in a matter before the High Court Pretoria, sitting at the Magistrates Court in Benoni, with a matter where he's been instructed, and the dates of the 11th to the 28th of August were set down prior to his engagement in the current trial. In support of his application, Mr. Hassan indicates that the challenge he would have is that accused number 1 would be severely prejudiced in the instance where the matter would proceed to trial in his absence. In broad strokes, the application that Mr. Hassan brings before this court is to indicate that for the days of the 5th and 6th of August 2026 that he is unavailable, he will make his instructing attorney, Mr. Strauss, available to stand in on his behalf so that there's no interruption in this particular matter. He seeks the indulgence of this court for not to attend the proceedings and to have the proceedings paused during the period Tuesday 11th to Friday the 28th of August 2026. That is how the court understands it in broad strokes. Mr. Hassan also points out during the course of his application that if one calculates the dates, it would in fact, if he were to be granted the indulgence, it would still amount to the 30 days, and to that extent, no real substantial prejudice would be suffered to any of the accused persons before this court. That, in broad strokes, as the court understands, is the application by Mr. Hissing for pausing the matter on the close of business Monday, the 10th of August 2026. The attorney for accused number 2, Mr. Nardis Rovia, indicates that he does not have any objection for the matter to stand down during the period 11 to the 28th of August 2026, and he also confirms on record that at all material times, counsel for accused number 1 had made himself crisply, clearly, and unambiguously clear on the previous occasion before the pre-trial court of his non-availability during this particular period. In essence, this application is not opposed by accused number 2. Ms. van der Heever, who appears on behalf of accused number 3 and 4, vigorously opposes the application and relies strictly on the order made by the pre-trial court that this matter should and must proceed during the period Monday 20th of July 2026 up until Friday the 18th of September 2026. The court pauses to mention that it has looked at the court file and confirms the ipse dixit of Ms. van der Heever that the court had indicated that this trial is set down for hearing uninterruptedly during the period 20th of July 2026 to proceed uninterruptedly. The order of the court reads as follows. It says, the trial date remains the 20th of July 2026 and to proceed uninterruptedly. It doesn't give a date as to when the matter is to come to an end in term 3. It just says it must proceed uninterruptedly. The court has carefully listened to the submissions made by the counsel for accused number 3 and 4 and has carefully also considered the objection raised for Mr. Hissing to be granted the application to have the matter paused for a period of 3 weeks. And that, in broad strokes, as the court understands, is the submissions made by counsel for accused number 3 and 4. Mr. Chauke appears on behalf of for accused number 5, indicates that he, in essence, does not have an objection to the application for the pausing of the matter at the instance of counsel for accused number 1 to be granted, and indicates that he will stand by any order of this particular court. That now brings me to Ms. Leroux, who appears on behalf of the state. Ms. Leroux has indicated that she also has a note that she made previously during the period from February 2026 through the different dates of counsel for accused number 1's non-availability, and in essence is not objecting to such an indulgence being granted. That, in essence, is the argument that has been raised for and against the grant of the application brought by counsel for accused number 1. The court places on record that it insisted on dealing with this particular aspect right at the outset and the commencement of the trial in order to become bogged down and to avoid being bogged down with any interlocutory issues that could raise its head during the course of the evidence that was being led in this trial. So despite the suggestion in chambers that this court should deal with this application upon or about the 5th or the 4th of August 2026, it was the view of this court and considered view that it would be inappropriate in the circumstances because each and every single party before this court should and must know with certainty as to what is going to happen moving forward. One can't leave this matter hanging in the air. I now turn to the application as well as the opposition to such an application. And for one moment, I place on record that I accept that my brother Karim AJ had indicated that this matter should run uninterruptedly from Monday the 20th of July 2026. And therefore, in the circumstances, this court is of the firm view that it is unnecessary for any party to produce a court order or the transcript, for the court has accepted that this is what that court had intended. Now we move to the point where this court, sitting as the trial court, is seized with this matter. In addition to the duties that this court has to listen to the evidence and to pronounce in the matter, it also is tasked to case manage the matter in order to ensure that there's a smooth flow of the evidence and that no party is being prejudiced. And at the cornerstone of this application and the opposition, the court simply has to carefully balance the constitutional rights guaranteed to the accused persons before this court, and that is the right to a fair trial, the right to a speedy trial, and for the court to determine if there's going to be any prejudice which is going to be suffered. And if prejudice is going to be suffered by a party, what order a court can make to avoid such prejudice, and that is only on the basis if there is prejudice being suffered. So in the circumstances, the court is of the view and clear that it accepts the order or the note made on the court file that the matter must carry on uninterruptedly. But today, this court is now faced with an application, and under those circumstances, it has to carefully apply its mind to what is before the court for practical purposes for the movement of this trial from the start to the end. The question is, are accused number 3 and 4 going to suffer prejudice if the matter is not going to continue during the period 17th to the 28th of August 2026? And to that extent, the simple test the court must go back to is a simple mathematical computation of the dates that this matter will be sitting. And to that extent, this matter is now destined to sit during the following period. It is going to sit from today, the Monday, the 20th of July 2026, up until the 7th day of August 2026. And the next dates that the court is going to be sitting, as proposed by counsel for accused number 1, is from Monday, the 31st day of August 2026, up until Friday, the 18th day of September 2026. It is undisputed, clear, and unambiguous when one refers to the court roll that this matter is set down for 30 days. If one computes the days as set down between the period Monday the 20th of July 2026 up until Friday the 7th of August 2026, and from Monday the 31st of August 2026 up until Friday the 18th of September 2026, it will amount, if not exactly or close to, the 30 days that this matter is set down. Therefore, in the circumstances, the considered view of this court is that there shall be no prejudice suffered to any of the parties before it if this court were to lean in favor to grant the application by counsel for accused number 1. Having read the documents before this court, having considered this matter, having heard counsel, the following order is made. It is ordered that 1, the trial in case number SS 98/2025 shall commence today, Monday, the 20th of July 2026, and shall continue uninterruptedly up until Friday, the 7th day of August 2026. The trial shall then pause during, number 2, the trial shall then pause during the period Tuesday, the 11th of August 2026, up until Friday, the 28th day of August 2026. 3, the trial shall resume again on Monday, the 31st day of August 2026, and shall continue uninterruptedly up until Friday, the 18th day of September 2026. That is the order of this court. Thank you.
As the court pleases.
As the court pleases.
Thank you, Ms. Levy. You may continue.
My Lord, the charges.
Sorry, just bear with me for one moment, please. Ms. Leroux, I'll propose that you will read each count to whichever accused it is. I'll let the accused plead and then we move count by count. Am I
As the
correct?
court pleases, my Lord.
Just bear with me for a moment, please.
Just want to make sure that Mr. Malafani, the interpreter, has got the charge sheet, the
So can I
indictment.
just, before you proceed to put the charges,
Yes.
Mr. Hassan, did you take instructions relating to whether we're going to proceed in English or isiZulu?
For purposes of the state's case, I confirm that accused number 1 is in a position to proceed in English.
Thank you very much. Accused number 2 is going to continue in English?
Indeed, so yes.
Ms. van der Heef, accused number 3 and 4? Thank you most kindly. Mr. Chauke, accused number 5? Thank you most kindly. Good. The court, having heard the submissions made by counsel and having considered the totality of the circumstances, is in agreement that for the purposes of the state case, we shall proceed in English.
As the court pleases, my Lord. Thank
Obviously, your witnesses will be a different issue altogether.
Yes.
Okay, just give me a second. Can I just perhaps also inquire from counsel, since we have taken some time this morning to deal with matters in chambers, and we're starting with the plea proceedings, would you perhaps be kind enough to allow us to complete the plea proceedings and don't take the long adjournment for now?
No objection.
Thank you. Thank you so much.
you. Thank you, my Lord.
Sorry, count 1 is to put to accused number 1, 2, and 3.
That's correct,
Okay,
my
just
Lord.
give me a second. Okay, just bear with me. Yes, thank you.
Count 1 is that of conspiracy to commit murder against accused number 1, 2, and 3 in that on or about the period leading up to the 10th of August 2022 and at or near Pretoria or another place unknown to the state and within the jurisdiction of the North Gauteng Division, Pretoria, the accused unlawfully and intentionally conspired with each other to aid or procure the commission or to commit an offence to wit the unlawful and intentionally killing of Mr. Madoda Johannes Sibanyone, my Lord, and I've already indicated there on the indictment that centralization was granted with regard to counts 1 to 8.
Mr. Musa Kekana, please, you can rise, sir. Do you understand the charge against you? How do you plead to the charge? Thank you. You may take a seat. Mr. Floyd Mabusela, sir, you may rise. Count number 1, the conspiracy to commit murder. Do you understand this charge against you, sir? How do you plead? Thank you. Mr. Vusimuzi, Matlala, sir, do you understand count number 1, which is a conspiracy to commit murder? And how do you plead to the charge? Thank you. You may take a seat. Count number 2.
Count number 2, my lord, is that of attempted murder. And here I just want to draw the court's attention that I'm relying on section 51(1), part 1 of schedule 2 of the Criminal Law Amendment Act, that is the Minimum Sentences Act. So, my lord, and that is the case with all the attempted murder charges. In that on the 10th of August 2022 and at or near John Foster Avenue, Centurion Golf Estate, and within the jurisdiction of the North Gauteng Division, Pretoria, accused number 1 and 2, with the knowledge and on instruction of accused number 3, that unlawfully and intentionally attempt to kill my daughter Johannes Sibanyoni by shooting at him and wounding him.
Count number 2, accused number 1, sir, Mr. Kekana. Count number 2, the charge of attempted murder. Do you understand this charge against you? And how do you plead to this charge? Thank you. Accused number 2, sir, you may rise. Do you understand count number 2, which is attempted murder? How do you plead to the charge? Thank you. Accused number 3, sir, do you understand the charge against you? How do you plead to the charge? Thank you. Count number 3.
Count 3 is also attempted murder, in that on the same time, date and place.
Sorry, one second, Ms. Leroux. This, every count of attempted murder is read with section 51(1).
Yes, my lord, and I would like the court to confirm that.
Just place on record, when you say section 51(1), just indicate to the accused the provisions of section 51(1).
Is that of life imprisonment?
Yeah, just indicate so that they understand before they plead to the charge.
Yes, my lord, I will do so. So that is then schedule, part 1 of schedule 2 of section 51(1) of the Criminal Law Amendment Act, 105 of 97, which now provides for life imprisonment even for attempted murder.
Okay, count number 3, yes, proceed.
So, count 3, in that on the same time, date and place referred to in count 2, accused 1 and 2, with the knowledge of accused number 3, that unlawfully and intentionally attempt to kill Sandile Welcome Masimule by shooting at him.
Accused number 1, you may rise, sir. Count number 3 is the charge of attempted murder, and I just want to, at the outset, I'll explain it to you at a later stage, but the state has preferred to charge you with attempted murder, read together with the provisions of section 51, subsection 1, which provides that in the ordinary course of business, unless there are truly seen to be substantial and compelling circumstances present, that the court ordinarily impose the sentence of life imprisonment in the event of a conviction. Do you understand that particular schedule that the state has indicated? In respect of count number 3, the attempted murder, do you understand this charge against you? How do you plead to the charge? Thank you.
Count 4, also that of
one
attempted
second.
murder.
1 second. I've got to do number 2 and 3.
My apologies, my lord.
Accused number 2, sir. Count number 3, the charge of attempted murder, you understand it? You also understand the explanation the state has given relating to the prescribed minimum sentence on the charge of attempted murder in the event if you are convicted. That is one of life imprisonment. You understand that? How do you plead to this charge? Thank you. Accused number 3, sir. Count number 3, the one of attempted murder. Do you understand the charge against you? And you also understand the explanation that the state has given relating to the application of the prescribed minimum sentence in the event of a conviction. How do you plead to this charge? Thank you.
Count number 4, attempted murder against accused number 1, 2, and 3, in that on the same time, date, and place referred to in count 2, accused 1 and 2, with the knowledge of accused 3, did unlawfully and intentionally attempt to kill Donald Mutau by shooting at him.
Accused number 1, sir. Do you understand count number 4, the charge of attempted murder? How do you plead to this charge, sir? Thank you. Accused number 2, sir, do you understand this count number 4 of attempted murder against you?
Yes, sir.
How do you plead to the charge? Thank you. Accused number 3, sir, do you understand count number 4, the charge of attempted murder? How do you plead to the charge? Thank you.
Count 5 is that of attempted murder against accused number 1, 2, and 3, in that on the same time, date, and place referred to in count 2, accused 1 and 2, with the knowledge of accused number 3, did unlawfully and intentionally attempt to kill Kayaletu Francis Mazibuko by shooting at him.
Accused number 1, sir, count number 5, the complainant in that matter is one Mazibuko. Do you understand the charge against you? How do you plead to the charge? Not guilty. And just remember that all the counts of attempted murder, the state has preferred to charge the accused with section 51, subsection 1. Okay? Good. Accused number 2, sir, do you understand this count number 5 of attempted murder against you?
Yes, sir.
And how do you plead to the charge? Thank you. Accused number 3, sir, do you understand this charge against you on count number 5? How do you plead? Thank you.
Count number 6 is that also that of attempted murder against accused number 1, 2, and 3, in that on the same time, date, and place referred to in count 2, accused 1 and 2, with the full knowledge of accused number 3, did unlawfully and intentionally attempt to kill Bethwel Mzamu Kele by shooting at him.
Accused number 1, sir. Count number 6, do you understand the charge against you? How do you plead to the charge? Thank you. Accused number 2, sir, do you understand the charge against you?
Yes, sir.
How do you plead to the charge? Thank you. Accused number 3, sir, do you understand the charge against you? How do you plead to the charge? Thank you.
Count 7 is that of the illegal possession of a prohibited firearm, an AK-47. My lord, that your lordship will find the reference to the specific legislation is, your lordship will find that on page 2, it is a contravention of section 41A, read with section 1, 103, 117, 120, brackets 1, brackets A, and section 121, read with schedule 4, and read with the provisions of, again, minimum sentences, section 51.2, and part 2 of schedule 2 of the Criminal Law Amendment Act 105 of 97, as amended, and further read with section 250 of the Criminal Procedure Act as amended. That is then a prohibited firearm, and I read that count out now. In that, on or about the same time, date, and place referred to in count 2, the accused did unlawfully have in their possession a fully automatic firearm, being a prohibited firearm, to wit a 7.62 9mm Russian model AK-47 assault rifle with a serial number 575363, without being the holders of a license.
Just want to double check the caliber. You read the caliber as 7.62 times 9 millimeter. The indictment shows 39
No, my lord, that
millimeter.
is, let me just go back there. It's a 0.762 39 millimeter.
I thought I heard you saying 9 millimeter.
Apologies if I said that. I meant to say 39 millimeter.
Good. Thank you. Accused number 1, sir. Count number 7, the state is charging you with illegal possession of a prohibited firearm, which is an AK-47. Do you understand this charge against you? How do you plead to this charge? Thank you. Accused number 2, sir. The state is charging you with count number 7, being in illegal possession of a prohibited firearm, an AK-47. Do you understand this charge against you? How do you plead to the charge? Thank you.
So then, count 8 is the illegal possession of the ammunition of this firearm. My lord, again, the reference to the legislation can be found on page 2 of the indictment. That is page 2 running over to page 3. Paragraph 5, my lord, on page 3, the contravention of section 90, read for sections 1, 103, 117, 120, brackets 1, brackets A and 121, and read with schedule 4 of Act 60 of 2000, further read with section 250 of the Criminal Procedure Act, unlawful possession of ammunition, and the count then reads as follows. In that upon or about the same time, date and place, refer to in count 2 the accused that unlawfully have in their possession ammunition to wit an unknown number of 7.62 millimeter rounds without being the holders of either a license, a permit, dealer's license, or was otherwise authorized to do so.
Accused number 1. Count number 8 is charging you with illegal possession of ammunition. Do you understand this charge against you? How do you plead to this charge? Not guilty, thank you. Accused number 2, sir, do you understand count number 8 against you?
Yes, sir.
And how do you plead to the charge? Thank you. You may be seated. Count number 9.
So, my lord, as your lordship will see from the indictment, I've divided the 25 charges as to and grouped them together as per incident. So the first incident was the Sibonyoni incident. So now we move over to the Tobiani incident. Count 9, a conspiracy to commit murder against accused number 1, 2, and 3 in that on or about the period leading up to 17 October 2023 and at or near Johannesburg or another place unknown to the state within the jurisdiction of the Gauteng local division, Johannesburg, the accused unlawfully and intentionally conspired with each other to aid or procure the commission of or to commit an offence to wit, to unlawfully and intentionally kill Tebogo Tobijane.
Accused number 1, on count number 9, the conspiracy to commit murder where the complainant is one Tebogo Tobijane. Do you understand this charge against you? How do you plead to the charge? Thank you. Accused number 2, sir, do you understand this charge against you, count number 9?
Yes, sir.
How do you plead to the charge?
Okay.
Thank you. Accused number 3, do you understand count number 9 against you? How do you plead? Thank you so much. You may be seated.
Count
Count
number
10.
Count number 10, 11, and 12 then again deals with attempted murder and again with the provisions of the Minimum Sentences Act, my lord. Count number 10, attempted murder, accused 1, 2, and 3, and accused 4 as an accessory after the fact, in that on the 17th of October 2023 and at or near the corner of Bryanston Drive and Wilton Drive, Johannesburg, within the jurisdiction of the Gauteng local division, Johannesburg, accused 1 and 2 with the full knowledge and on instruction of accused number 3 did unlawfully and intentionally attempt to kill Tebogo Tobijane by shooting at her.
Accused number 1, sir, the count number 10 is one of attempted murder. Also read with the provisions of section 51(1). Am I right, Ms. Leroux?
That is correct, sir, my lord.
Do you understand this charge against you? How do you plead to this charge? Not guilty, thank you. Accused number 2, sir, do you understand count number 10 against you?
Yes, I do.
How do you plead to the charge? Thank you. Accused number 3, sir, do you understand count number 10 against you? How do you plead? Sorry, not guilty. Thank you. Accused number 4, ma'am, do you understand count number 10, the charge of attempted murder? How do you plead to the charge? Thank you. Ms. Leroux, can I just ask you a question? In respect of the charge of attempted murder, accused number 4 is being charged as an accessory after the fact.
That's correct,
Just
sir.
help me with the 51(1).
My lord,
It's also applicable to her.
I think one should also, yeah, just for safety's sake, I'll just have to go and check, but I think for safety's sake it should also be explained to her.
Okay, so let me just explain it to you. Ma'am, you may rise. So the state in count number 10 is charging you with attempted murder, but they're saying that you've been charged as an accessory after the fact. But you will remember and recall that in respect of the charges of attempted murder, the state is preferring the provisions of section 51 subsection 1, which provides that in the event of a conviction on the charge of attempted murder, the ordinary prescribed minimum sentence to be imposed by a court, unless there are truly seen to be substantial and compelling circumstances that may cause it to deviate, would be one of life imprisonment. The state says for now it is asking the court to draw that to your attention. It may change its position later on in the trial. But just remember that that is what the state is intending to charge you with at this stage. So don't forget, okay? Good. You may be seated. Thank you, Ms. Leroux.
Thank you, my lord. Then account number 11, again attempted murder, same accused 1 to 3 and accused 4 as an accessory after the fact. In that on the same time they were placed referred to in count 10, accused 1 and 2 who acknowledged the accused number 3 that unlawfully and intentionally killed and murdered Anisha Malinga by shooting at her and wounding her.
Count number 11 is one of attempted murder of one Anel Alicia Malinga, also known as Japan. Accused number 1, do you understand this charge against you? How do you plead to the charge, sir? Not guilty, thank you. Accused number 2, sir, do you understand this charge against you?
Yes, I do.
How do you plead to the charge?
Not guilty.
Thank you. Accused number 3, sir, do you understand this charge against you?
Yes, I do.
How do you plead to the charge?
Not guilty.
Thank you. Accused number 4, ma'am, you've also been charged on this count as an accessory after the fact. Do you understand this charge against you?
Yes, I do.
How do you plead to the charge?
Not guilty.
Thank you. Count number 12.
That of attempted murder, accused number 1, 2 and 3 and accused 4 as an accessory after the fact. Doing that on the same time that the place referred to in count 10 accused 1 and 2 who have been wanted to accuse 3 that unlawfully and intentionally attempted to kill Kimberlani Mulde by shooting at him.
Accused number 1, sir. On count number 12, the complainant is one Kumbulani Ngube. Do you understand this charge against you?
I understand the charge.
How do you plead to this charge?
Not guilty.
Thank you. Accused number 2, sir, do you understand count number 12 against you?
Yes, I do.
And how do you plead to the charge?
Not guilty.
Thank you. Accused number 3, sir, do you understand count number 12 against you?
I do understand.
How do you plead to the charge?
Not guilty.
Thank you. Accused number 4, do you understand the charge against you on count number 12?
I understand my name.
How do you plead?
Not guilty.
Thank you.
Count 13, my lord.
Yes, thank you.
Illegal possession of a prohibited firearm and identity 7 in against accused number 1 and 2. in that on or about the same time that in place referred to in count 10, the accused did unlawfully have in their possession a fully automatic firearm, being a prohibited firearm, to wit a 7.62 39mm Russian model AK-47 assault rifle without even the holder of the license. My Lord, I've already placed the reference to the Firearms Act on record. I don't think it's necessary to do it again.
Thank you. Accused number 1, sir. Count number 13. The state is charging you with the illegal possession of a prohibited firearm and AK-47. Do you understand this charge against you? How do you plead to the charge?
Not guilty.
Thank you. Accused number 2, sir. Do you understand count number 13 against you?
Yes, I do.
And how do you plead to the charge?
Not guilty.
Thank you. Count 14.
Count 14 is illegal possession of ammunition against accused number 1 and 2, in that upon or about the same time that the place referred to in count 10, the accused did unlawfully have in their possession ammunition to wit an unknown number of 7.62mm rounds without being the holders of either a license, a permit, dealer's permit, or otherwise authorized to do so.
Accused number 1 on count number 14. The state is charging you with an unknown number of 7.62 rounds for the AK-47. Do you understand the charge against you? How do you plead to the charge?
Guilty.
Thank you. Accused number 2, sir. Do you understand count number 14 against you?
Yes, I do.
And how do you plead?
Not guilty.
Thank you.
Count number 15, my Lord, now going to the money laundering charge. That is against accused numbers 2, 3, and 4.
No, it says 2, 3, and 5.
Sorry, 2, 3, and 5. Correct. 2, 3, and 5. In that on or about the 12th of October 2023, and at or near the same place referred to in count 9, the accused acting in concert with one another and in lieu of all reason to have known that the property to wit 20,000 rand, which was or formed part of the proceeds of unlawful activities, that wrongfully and unlawfully enter into any agreement or engage in any arrangement or transaction with or in connection with the property to wit 20,000 rand, or perform any act in connection with such property to wit arranged that the said 20,000 rand be a portion of the compensation to kill the complainant in count 10 to be transferred from the business account of case number 3 into the business account of case number 5, whereafter a portion thereof, 15,000 rand, was further transferred into the business account of case number 2, which had or was likely to have the effect of concealing or describing the nature, source, location, disposition, or movement of the said property, or ownership thereof, of any interest which anyone may have in respect of thereof, and or enabling or assisting any person who has committed or commits an offence, whether in the public or elsewhere, to either avoid prosecution or to remove or diminish the said property acquired directly or indirectly as a result of the commission of an offence. The penalty clause is quoted there, section 8, bracket 1. Any person convicted of an offence contemplated in section 4, 5, and 6 shall be liable to a fine of exceeding 100 million rand or to imprisonment for a period of not exceeding 30 years.
Accused number 2, sir. The state on count number 15 is charging you with money laundering. Do you understand this charge here?
Yes, I do.
And have you also noted the penalty provision?
Yes, I have.
How do you plead to the charge?
Not guilty.
Thank you. You may be seated. Thank you. Accused number 3, sir. The state on count 15 is charging you with money laundering. Do you understand this charge against you?
Yes, I do.
How do you plead to the charge?
Not guilty.
Thank you. Accused number 5, ma'am. It's Miss Zandile Ntabiseng Nzama.
Yes,
Count number 15. Do you understand the charge of money laundering against you?
yes I do.
How do you plead to the charge?
Not guilty.
Thank you. You may be seated.
I just refer the court again to page 3 of the indictment, my Lord, where reference is made to the particular section of FOFA. That is contravention of section 4A, 6, slash B 1/2, read with the provisions of Section 1 and the Section 8 of the Prevention of Organised Crime Act number 121 of 1998. Further also read with Section 51(2) Part 2 of Schedule 2 of the Criminal Law Amendment Act. In other words, there is also a minimum sentence in place there. That's correct, my lord.
So the state is preparing to charge the accused with the provision of section 51 subsection 2.
That is correct, my lord.
I will explain that to you later. You can now move to count 16.
Count 16, money laundering, against accused number 2, 3, and 5 again. It's the same section, in that on the 18th, on or about the 18th of October 2023, at near the same place, referred to in count 9, the accused acting in concert with one another, and who knew or ought reason to know that the property to wit 100,000 rand, which was or formed part of the process of unlawful activities, did wrongfully and unlawfully enter into any agreement of, or engage in any arrangement or transaction with or in connection with the property to wit 100,000 rand, or performed any act in connection with such property to wit, arranged that the said 100,000 rand being a portion of the compensation to kill the complainant in Gauteng to be transferred from the business account of accused number 3 into the business account of accused number 5, whereafter a portion thereof was further transferred into the business account of accused 2, which had or was likely to have the effect of concealing or disguising the nature, source, location, disposition, or movement of the said property or ownership thereof of any interest which anyone may have in respect thereof, and or of enabling or assisting any person who has committed or committed an offence, whether in the Republic or elsewhere, to avoid prosecution or to remove or diminish the said property acquired directly or indirectly as a result of the commission of an offence.
Count number 16. Accused number 2, sir. The state is preparing a charge of money laundering against you in the amount of 100,000 rand. You understand this charge against you?
Yes, I do.
And how do you plead to the charge?
Not guilty.
Okay. Accused number 3, sir.
Count number 16. Do you understand this charge against you?
Yes, I do.
How do you plead to the charge?
Not guilty.
Thank you. Accused number 5. The state is charging you with money laundering on count number 16. Do you understand this charge?
Yes, I do.
How do you plead?
Not guilty.
Thank you so much. You may be seated. Count number 17.
Number 17, my lord, is against accused also money laundering, and it is the same provision, section 4, as accused number 2, 3, and 4 this time, in that on about the 19th of May 2025, and acting the source will be in the jurisdiction of the Gauteng Local Division Management accused 4, acting in concert with accused number 2 and 3, and who knew or ought reason to have known that the property to be 20,000 rand and the 100,000 rand referred to in counts 15 and 16, respectively, is was or formed part of the process of unlawful activities, but wrongfully and unlawfully entered into any agreement or engaged in any arrangement or a transaction with or in connection with the property to which the said money referred to in counts 15 and 16, or performed any act in connection with such property to which arranged that a false invoice be created by corporal funeral parlour in the amount of 70,000 rand, which had or was likely to have the effect of concealing or disguising the nature, source, location, disposition, or movement of the said property or invoice, or ownership thereof, of any interest which anyone may have in respect thereof, of enabling or assisting any person who has committed or commits an offence, whether in the Republic or elsewhere, to avoid prosecution or to remove or diminish the said property acquired directly or indirectly as a result of the commission thereof. My lord, I think I should just make a minor amendment here. It should read a false invoice or a receipt.
Just draw my attention? Where do you want
My Lord, it's the bolt type. If your Lordship will have regard to the portion
It says the board in counts 15 and
16.
With regard to count 17, my Lord.
yeah.
But in line number 1, 2, 3, 4, 5, 6, in line number 7,
That's correct, my Lord.
where it reads arranged that a false invoice, and you want the included and or receipt.
That is correct, my Lord.
Let me just hear. Mr. Kassing, any objection to that amendment?
No objection.
Mr. Proviesa?
No objection, my lord.
Now,
This one here, thank you. Mr. Chowke?
No objection.
Thank you. The state in count number 17 brings an application for the amendment of the indictment to include in line number 7 on count number 17 to read as follows: arrange that a false invoice to include and or receipt be created by Poku Funeral Parlour in the amount of 70,000 rand. The application for amendment of the indictment is not opposed by counsel. Accordingly, the application is granted, and accordingly, the count shall read as follows. In line number 6, it will read as in counts 15 and 16, or performed any act in connection with such property, to wit, comma, arrange that a false invoice and or receipt be created by Poku Funeral Parlour in the amount of 70,000 rand, which had or was likely to have the effect. Good? Granted, thank you.
count 18, that is fraud against accused number 3 and 4. In that, on or about the same time, date and place referred to in count 17, the accused had unlawfully, falsely, and with the intent to defraud and to the prejudice of, or the potential prejudice of the regional court in Alexander, who was to hear the bail application of accused number 3, or any other court of law who is to preside over the matter, and or South African or the South African police give out and refer and pretended that the invoice again and or receipt, my Lord, referred to in count 17 is a true reflection of the source of the money referred to in count 15 and 16. So this is another amendment, my Lord. In other words, if your Lordship will have regard to page 12 on the 4th line from the top, where it starts with invoice, I would want to insert there and or receipt.
Any objection?
None, thank you, my lord.
Thank you, Mr. Provera.
Strictly speaking, count 18 is not relevant to accused number 2, my lord, but there is no objection.
No objection, my Lord.
Mr. Chowke?
I share the sentiments of the counsel for case number 2.
Thank you. Carry on with count 18 and thereby attempt to induce the courts and South African Police Service to accept that the money so paid was for a lawful purpose with the aim to create a defence and either avoid arrest or prosecution, or to, after the arrest of accused 3, to be granted bail during his bail application in the Alexandra court. Whereas in truth and in fact, the accused gave out and pretended as aforesaid that they knew that the invoice and again and or the receipt was fraudulent and not a true reflection of the reason why the money was paid by accused 3 into the business account of accused 5 and later transferred into the business account of accused number 2.
I just want to confirm, with respect to count number 17, I did ask the accused to plead the matter.
That is correct, so my Lord. Not yet, my Lord.
Yes. Count number 17, the charge of money laundering, where the state asked for an amendment now from that a false invoice and a receipt to be created. Accused number 2, do you understand the charge against you in count number 17?
Yes, I do.
How do you plead?
Not guilty.
Thank you. Accused number 3, count number 17, do you understand?
Yes, I do.
How do you plead?
Not guilty.
Accused number 4, ma'am, do you understand count number 17?
Yes, I do.
How do you plead?
Not guilty.
Thank you. Count number 18, accused number 3, sir. the charge of fraud. Do you understand this charge against you?
Yes, I do.
How do you plead to this charge?
Not guilty.
Not guilty, thank you. Accused number 4, do you understand count number 18 against you? How do you plead?
Not guilty.
Thank you. Thank you. Let's go to the alternate to count 18, am I right?
That is correct, sir, my lord, in attempt to defeat the administration of justice, that is with regard to accused number 3 and 4.
Yes.
In that honour, about the same time that the place referred to in count 18, the accused of wrongfully and intentionally attempt to defeat or obstruct the course of justice by arranging for the creation of the fraudulent invoice and or receipt referred to in count 17 and 18 in an attempt to convince the court, the SAPS, that the money referred to in count 15 and 16 was a bona fide payment for the funeral of accused number 2's mother, namely Tesha Nelly Rebecca Marusela, whereas in fact it was payment for the killing of the complainant sin.
Accused number 3, the state, in addition to the main count of fraud on
Count 18 has preferred to charge you with the alternate to count number 18, which is an attempt to defeat the administration of justice. Do you understand this charge against you?
Yes, I do.
How do you plead to this charge?
Not guilty.
Thank you. Accused number 4, do you understand the alternate to count number 18?
Yes, I do.
How do you plead?
Not guilty.
Thank you.
count number 19.
Yes, now we move over to the Mokboom incident, the last few charges. Again, my lord, centralization was granted on the 23rd of October 2025. Count number 19, conspiracy to commit murder, accused number 1, 2, and 3, in that on or about the period leading up to 29 January 2024 and at or near Pretoria or another place unknown to the state and within the jurisdiction of the North Gauteng Division, Pretoria, the accused unlawfully and intentionally conspired with each other to aid or procure the commission of or to commit an offence to which to unlawfully and intentionally kill Austin Simply Mokboom, aka DJ Betty.
Thank you. Accused number 1 and count number 19, do you understand the charge against you of 1 to commit conspiracy, to commit murder? Do you understand the charge against you? How do you plead to the charge?
Not guilty.
Thank you. Accused number 2, sir, do you understand count number 19 against you?
Yes, I do.
How do you plead?
Not guilty.
Thank you. Accused number 3, sir, do you understand count number 19?
Yes, I do.
How do you plead, sir?
Not guilty.
Thank you. You may be seated. Count number 20.
Is that of attempted murder, and again, the state will rely here on the minimum sentences legislation against accused number 1, 2, and 3, in that on the 29th of January 2024 and at O'Neill Stuffen and WFB Cormer Streets, Pretoria West, and within the jurisdiction of the North Gauteng Division, Pretoria, accused 1 and 2 with the full knowledge and on the instruction of accused 3 that unlawfully intentionally attempt to kill Austin Simply Mokboom, aka DJ Betty, by shooting at him and wounding him. Good.
Accused number 1, sir.
Count number 20, the one they're charging you with attempted murder. Do you understand this count against you?
I understand.
How do you plead to the charge? Thank you. Accused number 2, sir. Do you understand count number 2, the charge of attempted murder against you?
Yes, I do.
And how do you plead?
Not guilty.
Thank you. Accused number 3, sir. Do you understand count number 20, the charge of attempted murder?
Yes, I do.
How do you plead?
Not guilty.
Thank you.
Then count 21, my lord.
Count 21, yes.
Attempted murder, accused 1, 2, 3, in that or near the same date and place referred to in count 20, accused number 1 and 2, with the knowledge of accused number 3 that unlawfully and intentionally attempt to kill Leonard Buntle Masongu by shooting at him and wounding him.
Count number 21. Accused number 1, sir. Count number 21, the charge of attempted murder. Do you understand the charge against you? How do you plead to the charge? Thank you. Accused number 2, sir. Do you understand count number 21, the one of attempted murder against you?
Yes, I do.
And how do you plead to the charge?
Not guilty.
Thank you. Accused number 3, sir. Do you understand count number 21, the charge of attempted murder against you?
Yes, I do.
And how do you plead to the
Not
charge?
guilty. Not guilty.
Thank you. Count 22.
Count 22 also that of attempted murder, accused number 1, 2, and 3, in that at or near the same date and place referred to in count 20. Accused 1 and 2 with the knowledge of accused 3 did unlawfully and eventually attempt to kill Sparello Tsipiso Pizze by shooting at him and wounding him.
Accused number 1.
On count number 22, the attempted murder, do you understand the charge against you? And how do you plead to the charge?
Not guilty.
Thank you. Accused number 2, sir. Do you understand count number 22, the charge of attempted murder against you?
Yes, I do.
And how do you plead to the charge?
Not guilty.
Thank you. Accused number 3, sir. Do you understand the charge of attempted murder on count 22 against you?
Yes, I do.
How do you plead to the charge?
Not guilty.
Thank you. Count number 23.
Illegal possession of a prohibited firearm. At this time it's a 9mm pistol against accused number 1 and 2 in that on or about the same time, date and place referred to in count 20. Accused 1 and 2 that unlawfully had in their possession a 9mm Parabellum Calibratorius model PT-92FS semi-automatic pistol of which the serial number or any other identifying mark has been changed or removed without the permission of the registrar, being a prohibited firearm. My Lord, the reference to the section, the court can find that on page 2 of the indictment, that is contravention of section 4, brackets 1, brackets F, brackets Roman 4, read with section 1, 103, 117, and 120, and also section 121 of the Firearms Control Act, and the Schedule 4 thereof, as well as section 51(2), part 2 of the Schedule 2 of the minimum sentences regime, so there is also a minimum sentence involved there.
Good. Count number 23. Accused number 1. The state is charging you with the illegal possession of a prohibited firearm, a 9mm firearm. Do you understand the charge against you? How do you plead to the charge? You accused number 2, sir. Count number 23. Do you understand the charge of being in possession of an illegal or being in illegal possession of a prohibited firearm? Do you understand the charge?
Yes, I do.
How do you plead?
Not guilty.
Thank you. Count 24.
Illegal possession of ammunition against accused number 1 and 2 in that upon or about the same time, date and place referred to in count 20, the accused did unlawfully have in their possession ammunition to wit an unknown number of 9mm rounds without being the holders of a license, permit, or a dealer's license or otherwise authorized to possess such ammunition.
You accused number 1, sir. State is charging you with the illegal possession of ammunition of an unknown number of 9mm rounds. Do you understand this charge against you on count 24? How do you plead to the charge? Thank you. Accused number 2, sir. Do you understand this charge against you?
Yes, I do.
On count 24?
Yes, I do.
How do you plead to the charge?
Not guilty.
Thank you.
Then
Count
25, the last charge, my Lord, is that also money laundering. Again, your Lordship will find the reference there on page, let me just quickly find that. On page 3 of the indictment, paragraph 6 there.
Yes.
So money laundering against accused number 2, 3 and 5 in that on or about the 24th of January 2024 and that will be the same place referred to in count 19. The accused acting in concert with one another and we knew or ought to have known that the property to wit 10,000 rand, which was or formed part of the proceeds of unlawful activities that wrongfully and unlawfully enter into any agreement or engagement in any arrangement or transaction with or in connection with the property to wit the 10,000 rand or perform any act in connection with such property to wit arrange that the said 10,000 rand being a portion of the compensation to kill the complainant in count 20 to be transferred from the business account of accused 3 over into the business account of accused 5, whereafter a portion thereof was further transferred into the business account of accused 2, which had or was likely to have the effect of concealing or disguising the nature, source, location, disposition or movement of the said property or ownership thereof of any interest which or of any interest which anyone may have in respect thereof, and or of enabling or assisting any person who has committed or commits an offence whether in the Republic or elsewhere, to avoid double A, to avoid prosecution or to remove or diminish the said property acquired directly or indirectly as a result of the commission of an offence. The same penalty clause applies. So, my lord, that is the end of the charges.
Good. Count number 25, the charge of money laundering, accused number 2. Do you understand this charge of money laundering against you?
Yes, I do.
And how do you plead to the charge?
Not guilty.
Thank you. Accused number 3, sir. Do you understand count number 25, the charge of money laundering against you?
Yes, I do.
How do you plead?
Not guilty.
Thank you. Accused number 5, ma'am. Do you understand count number 25, the charge of money laundering against you?
Yes, I do.
How do you plead?
Not guilty.
Thank you.
Does the court require me to read the summary of substantial facts?
Just give me 1 second. I don't think it's necessary. Councillor, can we take it as deemed to be read?
It's never been done
Yeah.
for something.
Can we just, the indictment's been there before everyone, I'm certain we all are able to read the summary substantial.
Correct, thank you, Bob.
Thank you so much. Mr. Frovia?
In agreement, my lord.
Mr. Chaplain?
I'm also in agreement.
Well done. You're not standing by your colleague, this time you're in agreement. Just before I ask Councillor, Ms. Leroux, I just want to be certain that we are on the same page and that we are not. So, count 1 is conspiracy to commit murder. It's not read with the provisions of any minimum sentence, am I right? Count 2 is attempted murder, read together with 51-1.
That's correct.
Count 3 is attempted murder, read together with 51-1. Count 4 is attempted murder, read together with 51-1.
Yes, correct.
Count 5 is attempted murder, read together with 51-1. Count 6 is attempted murder, read together with the provisions of section 51-1.
Yes.
Count 7, illegal possession of prohibited firearm. What does that tell me?
My lord, that is 15 years?
Count 7.
Yes.
Just show me on
25. My lord, my colleague here informed me it's actually 25 years.
prohibited firearm is 25 years.
Mr. President, you disagree?
Thank you.
I agree, thank you.
Well done. Count number 8, illegal possession of ammunition. Is there any prescribed minimum there?
Lord, just look at my indictment. Yes, indeed. 51-2.
51-2.
That is 15 years old.
Correct.
Conspiracy to commit murder. Count number 9, there's no prescribed minimum.
No, no.
Count number 10, attempted murder, section 51-1. Count 11, attempted murder, section 51-1. Count number 12, attempted murder, section 51-1. Count 13, illegal possession of prohibited firearm. It's 25 years minimum, am I correct?
Correction, my lord.
Illegal possession of firearm, count number 14. Happy with count 14?
Is that correct, my lord?
What is count 14?
That
Of ammunition, sorry.
15 years, yes.
Yes.
That's correct.
Count number 15 is money laundering, section 51,
Subsection 2. Count number 16 is money laundering, section 51, subsection 2. Count 17 is money laundering, section 51, subsection 2.
Yes.
Count 18 is fraud.
That's correct, my lord.
No prescribed minimum.
None, my lord.
Good. Count the alternative count number 18, attempted to defeat the administration of justice. No minimum.
No, no, no.
Count 19, conspiracy to commit murder. No minimum.
That's correct, my lord.
Count 20, attempted murder, section 51.1.
That's correct, my lord.
Count 21, attempted murder, section 51.1.
That's correct.
Count 22, attempted murder, section 51.1.
Yes.
Count 23, illegal possession of a prohibited firearm, 25 years.
That's correct, my lord.
Illegal possession of ammunition, 15 years.
Yes.
Money laundering.
That's for 15 years.
The penalty provision is there on page 16, money laundering.
Yes.
You've seen that.
Yes, my lord.
So we are all on the same page.
Correct, my lord.
Good. Right. Mr. Officer, let me hear you now in respect of the case number 1. Just bear with me,
Thank you.
let me put my-
My lord, I confirm on behalf of accused number 1
Sorry, 1 second, just give me a moment. Alright, yes, what is it?
I confirm that on behalf of accused number 1 that my instructions are that his plea of not guilty is in fact in accordance with my instructions on the charges proffered, pleaded upon. I further confirm that no plea explanation pursuant to the provisions of section 115 of the Criminal Procedure Act will be made, and that is my instructions that the accused elects to remain silent and put the state to the proof of the elements as proffered in the various charges contained in the indictment. Court pleases.
Thank you so much. Mr. Khove, for accused number 2, sir.
May it please the court, my lord, I confirm that in respect of counts 1 to 17 and 19 to 25, the plea of accused number 2 is in accordance with my instructions. There is no plea explanation at this stage of the proceedings. As indicated to your lordship, there are certain admissions that will be made in terms of section 220 of the Criminal Procedure Act, number 51 of 1977, which will be dealt with tomorrow morning. May it please the court.
The accused accordingly elects to remain silent.
Yes, indeed, sir, my lord.
Ms. van der Heever, thank
May
you.
it please the
For
court, my lord.
accused number 3.
On behalf of accused number 3, these pleas are in accordance with my instructions on all the charges preferred against him as per the indictment. The accused vehemently denies his involvement in any of the allegations set out in the charges. And the state
Yes.
is put to the proof thereof. We do intend, however, my lord, tomorrow to make certain Section 220 admissions that relates to the injuries and has bearing on the J88, and that we do to try and curb the proceedings before your Lordship.
Excellent.
My Lord, in respect of accused number 4,
Yes.
again, her pleas are in accordance with my instructions on all the charges preferred against her. Again, the state is put to the proof of all the allegations preferred against the accused. She denies her involvement in any of the charges with reference to the allegations set out in the charge sheet. As I said, and the state is put to the proof thereof. Again, similarly with her insofar as it is relevant, certain Section 220. Admissions will be made tomorrow, my Lord, again, in order to curb the proceedings before your Lordship. May it please the Court,
Thank
my
you
Lord.
so much. Thank you. Mr. Chowke, on behalf of accused number 5, sir.
As the court pleases, my lord, in respect of charge number 15, 16, and 25, the plea is in accordance with my instructions. There are certain admissions that we will make, and we will also make our submissions tomorrow in the morning. However, in respect of the others, the accused will exercise her right to remain silent.
Section 150 address, and there should be a copy available for all parties. I think we disseminated it.
Lord, I know my learned friend has said that she's left some documents for us here, but we can't seem to find those documents. In all the documents that she left this morning, it's disappeared somewhere here.
Lord, I made 8 copies.
I need to withdraw what I said this morning.
I've made 8 copies and it should be available.
Let me hear you. We'll let Ms. Leroux deal with the Section 150 address. The court wants to explain the provisions of the Minimum Sentences Act to the accused, and that will bring us to the point where we are now ready to commence the evidence. I just want you to think about it, whether you would prefer that we start afresh tomorrow morning with the evidence of the witness for the state. We crack it at 10 o'clock in the morning. The accused persons have not had the opportunity to take a lunch break. I expect them to have the lunch. So I think let's just finish these preliminary proceedings and let's adjourn for the day, and we'll commence tomorrow in the morning with the evidence of the first witness. Any objection, Mr. Fusen?
No, I'm in agreement. Thank you.
Mr. Provier?
I'm also in agreement, thank you,
Thank you. Ms. van der Heever?
My Lord, I will agree at this point in time. I do stand, however, by what I said this morning. I wish us to use all the call time that we possibly can. May it please the
Excellent.
Court.
Thank you so much. Mr. Chowke?
My lord, I cannot agree more.
I'm glad.
Nature is dictating.
Yes. Good. Right. Are we in possession of the Section 150 addresses of the state?
She
If you
can
don't
read it,
have
my Lord, it's fine.
Yeah, but if you don't have it, then you know what I suggest? Just listen carefully.
My Lord, what I undertake to do is I'll email them the document this afternoon after the meeting. But they should be able to find it there somewhere in what seems to be in the chaotic there on the defense side.
Excuse me.
The accused person was Joseph Getty. This is the section 150 address where the counsel for the state is going to indicate to us as to what the matter is about and what she intends doing. And the roadmap of where they're going to take it along. Good. Thank you, Mr. Murundi.
Thank you, my Lord. Again, I'm starting with the Sibanyoni incident, which relates to count 1 to 8. Paragraph 1 on page 1. The complainants in counts 2, 3, and 4 will testify as to their whereabouts the evening of 10 August 2022, which route they travelled, and how Mr. Sibanyoni was shot and wounded during the incident. They were parked, paragraph 2 on page 2, they were parked just outside the entrance to the country club in Centurion when they witnessed a white BMW approaching. When the BMW was next to them, shots were fired from this BMW at them. Mr. Sibanyoni was seriously injured. Paragraph 3. They are listed as follows in the list of witnesses for the state. My daughter Johanna Sibanyoni is witness number 1, Sandile Welcome Masimule, witness number 2, and Donald Katau, number 3. Paragraph 4. Mr. Sibanyoni, currently the president of Salpool Taxi Association, will also testify as to the history between him and the late Jotam Zanvula Msibi, also known as Mswazi or Mswati, and that there was some time before this incident animosity between them. He will also confirm that accused number 3 provided protection services to Mswazi through his accused number 3's company, CAT Security Services. Paragraph 5. The security guards, which is complainants in counts 5 and 6, respectively, were on duty at the Centurion Country Club that night. That is Kayaletu Francis Mazibuku, number 4, and Besboom Zamu Kayale, number 6. Paragraph 6. They were on guard just outside the security entrance of the country club. Mr. Kayale was armed and Mr. Mazibuku not. Paragraph 7. The moment the shooting commenced, they jumped for cover and Mr. Kayale opened fire from where he was hiding in the direction of the BMW. Paragraph 8. The BMW sped off and the police later arrived at the scene, one of which was Sergeant Camelo Tsipo, number 7. He also viewed video footage of the incident. Paragraph 9. Bidvest Coin was the security company responsible for managing the security of the estate, and as such also the custodians of the video footage that were available of the incident. The site manager of the security company who authorized the release of the video footage to the SAPS was Dewald Vryland, number 5. The video footage will be presented in terms of Section 15, read to Section 14 of the Electronic Communications and Transactions Act, number 25 of 2002. Paragraph 11. Constable Marito Nguveni, number 10, was the police official on the scene who assisted the photographer during the crime scene investigation. Paragraph 12. Constable Sipu Frans Monyai, number 11, was the photographer and crime scene investigator. He collected 21 cartridges on the scene that night. He sealed the said exhibit and it was subsequently delivered to the Forensic Science Laboratory in Victoria. Paragraph 13. Warrant Officer Ntubeleng Petrus Leboni, number 26, received the said 21 cartridges and identified the caliber as a 7.662 AK-47 assault rifle. He is from FSL in Victoria. I didn't mention that. He further indicated that there were two separate AK-47s fired on the scene. Paragraph 14. Ledili Dora Papu, number 11, was the previous girlfriend of accused number 3. She will testify that accused 3 contacted her that night of the 10th of August 2022 and requested her to keep a motor vehicle in her garage overnight. She was not home at the time and requested her helper, Mabaholo Mary Baholo, number 12, to attend. upon her return home the next morning, she noticed a white BMW parked in the garage. She went out again. Accused number 3 phoned her that morning, saying that there would be people coming to fetch the car. When she got home later, the motor vehicle was no longer there. Paragraph 15. Sergeant Matlala, Richard Masondu, number 14, was the previous investigating officer and collected the video footage on a memory stick of the shooting, as well as footage from the Nickel Way shopping centre in Sandton, where the Uko restaurant is situated, which he later handed over to the new investigating officer in the person of Sergeant Sipelo Ernest Sitole, number 46. Uko restaurant is the restaurant where Mr. Sibanyoni and his companions spent the evening, where they had dinner before the shooting. They left the shopping centre approximately just after 10 o'clock that evening and drove back to Mr. Sibanyoni's residence in Centurion. Sergeant Masondu also confirmed that upon his visit to the scene sometime after the incident, he found a piece of a right side mirror, white in colour, of a BMW. He kept it in a sealed forensic bag until it was collected from him by one of the new investigating officers, Warrant Officer Kurombi, number 54. Paragraph 16. Giyani Shadrack Manyiki, that is number 14, is the site manager of the Nickel Way shopping centre and confirmed the handing over of the video footage to Sergeant Masondu. Similarly, this video footage will be presented in terms of section 15 Supra. Paragraph 17. Nicolaas Jacobus Venter, number 15, confirmed that he did the backup of the video footage that night. He was approached by Warrant Officer Kurombi sometime after the incident with a request to be provided with the footage of the incident, which he did. Brian Mulefi, that is paragraph 18. Brian Mulefi Sutumi, number 18, will testify in Suraga that him and accused number 2 are friends. Sometime in August 2022, accused 2 brought a white BMW 335 series to sell, for him to sell. The BMW had several bullet holes in the body of the motor vehicle, and the right mirror was damaged. He had the car fixed and sold it to Sandam Pillay, who in turn sold it to Ali Alfred Idris, number 16. Mr. Idris confirms that Warrant Officer Kurombi seized the BMW from him on the 19th of June 2025. Sergeant W. Mkabele, number 19, will confirm that he received the memory stick from Warrant Officer Kurombi in the SW13 exhibit store on the 19th of June 2025. Similarly, Warrant Officer Matsubani Isaac Lahori, number 20, confirms the booking in of the side mirror handed in by Warrant Officer Kurombi. Warrant Officer Kurombi confirms all of the above and that he handed the BMW in at the VISS, that is the Vehicle Investigation Section of the SAPS. The BMW was no longer white in colour but wrapped in green. He will also testify to the fact that he removed one of the mirrors from the BMW it seized and handed that together with the side mirror recovered from the crime scene to FSL for comparison. On the 21st of June, that is paragraph 22, Captain Morisani, number 24, from the ballistic section of the Forensic Science Laboratory, proceeded to the VISS unit, where he found the said BMW. He examined the paintwork and the rest of the body of the motor vehicle, inside and outside. He uncovered several previously repaired bullet holes. He concluded that the BMW was shot at not less than 6 times with a low velocity firearm. Paragraph 23. Captain Deborah Blondie Mapitso Matlala, number 21, attached to the scientific analysis section of the Forensic Science Laboratory, analyzed the 2 side mirrors referred to above and concluded that they were manufactured in the same batch. Paragraph 24. Captain Melvin Kamo Mkachwa, number 77, attached to the ballistic section of the Forensic Science Laboratory, links the AK-47 recovered on the 17th of April 2024 to the scene at the country club where the shooting took place. Sunroll was approached by way of a Section 205 subpoena to obtain data from the toll gantries. Sebastian Pillay, number 28, and Nompumelelo Yenda, number 29, will testify to the movement of the BMW on the night of the incident, and that the BMW displayed the following registration plate, KJ 13JBGP. Colonel Maria Sarah Magita Brown, number 23, is attached to crime intelligence and compiled an analysis of the cell phones belonging to Mr. Simonyoni, accused number 1, 2, and 3, and also Michael Pulitao, and accused in another matter. From the cell phone records, she inter alia found that there was intense cell phone communication between the cell phones of accused number 1 and 2, before, during, and after the incident. She further placed their cell phones at the Uko restaurant shortly before Mr. Savanioni and his friends left on their way home. She also placed their cell phones close to the crime scene at the time of the shooting. Paragraph 27. Karen Barras, number 22, is an analyst attached to CAP Security, a security company who assisted the police in the investigation. She inter alia did an analysis of the movements of the cell phones of Mr. Sibanyoni and, amongst others, the cell phones of accused number 1 and 2 that night. She further compared it with the toll gantries on the route between Uko Restaurant and the Centurion Golf Estate. Paragraph 28. Nomaswazi Mokwena, number 27, is an official from the Department of Transport and Public Works in Gauteng, and opposed to 2 Section 212 affidavits pertaining to the information on the e-notice system on 2 registration plates, namely KJ13JBGP and LZ87SHGP. The importance of this is that the information on the e-notice system shows that the KJ number belongs to a Renault motor vehicle and not a BMW. Furthermore, the BMW was registered to the name of case number 2's daughter, Sandile Ntabiseng Mzama. The Tobijani incident, counts 9 to 14, paragraph 29. The complainants in counts 10 and 11, that is Teboka Tobijani, number 31, and Anele Alicia Malinga, aka Japan, number 32, as well as Antoinette Nandin Pretorius, number 34, and Natasha Mube, number 35, spent the day of the incident, that is 17 October 2023, together at the Grand, which is an adult entertainment venue in Sandton. They left the place shortly before 1800 hours that evening and drove to Morningside Shopping Centre, not far from there. They spent the rest of the evening at the Signature restaurant until around 2200 hours. When Ms. Tobijani phoned her driver, Mr. Kumbulani Mube, number 33, the complainant in count 12 to pick them up. Ms. Tobijani and Ms. Malinga were together in the black wrapped BMW, driven by Mr. Mube, and the other 2 witnesses were in Ms. Victoria's Audi when they left the restaurant. Ms. Victoria's will testify that she was aware of her WV caddy behind them at that stage. Paragraph 32. They stopped at the red traffic light at the corner of Bryanston and Walton Drive shortly after 2200 hours that evening. Ms. Pretorius will further testify that the Volkswagen Caddy came past her car, and when it was parallel with the BMW of Mr. Bajani, the occupants started firing shots at the BMW. She noticed a long gun protruding from the front passenger side of the Caddy. Paragraph 33. Ms. Malinga was seriously injured during the shooting incident and was rushed to hospital. She, and this is now in brackets, was left severely handicapped after this incident because of the injuries and walks today with great difficulty. Paragraph 34. Mr. Mube, upon a request from the police, took the motor vehicle back to the scene after the shooting later that night, where the police photographer, warrant officer Mashakeni, that is number 37, took photos of the crime scene. Paragraph 35. Sergeant Matinya Jeffrey Macheru, number 36, was the first investigating officer. During his investigation, he obtained video footage from the Morningside Shopping Centre. This video footage will be presented in terms of Section 15, read with Section 14 of the Electronic Communications and Transactions Act, number 25 of 2002. This footage shows the arrival of the complainant and her friends at the shopping centre at around 5:45 on the 17th of October 2023 and proceeding to signature. It also shows the arrival of a silver VW Caddy with registration number HV24DXGP almost immediately after they entered the basement parking lot, and two males excited the Caddy. These two men are then seen over the next few hours loitering around the inside and outside of the shopping centre with no apparent purpose. The state alleges that one of these males were accused number 1. Paragraph 36. Sergeant Macheru further discovered that one of these males bought airtime at Woolworths early that evening. This was followed up, and the voucher number for the airtime is linked to a phone number that called Carol Macatini. Paragraph 38 deals with that below. The night of the incident, the SIM card was later placed into a cell phone handset which was seized in a Mercedes-Benz Viana on the 17th of April 2024. Accused 1 and Michael Pulitao were arrested in this vehicle. As a result of this arrest, Tao is currently accused number 1 in a murder case that will be set down for trial due to commence on the 26th of October 2026. Musa Kekana and Tia Floyd Mabusela, accused number 1 and 2, are respectively accused 2 and 3 in that matter. Paragraph 37. The registration number of the Volkswagen Caddy referred to above was picked up on the license plate recognition cameras, that is LPR cameras, earlier that day near the Grand, but also at the corner of Bryanston and Walton Drive at the time of the shooting. Paragraph 38. Upon further investigation, it was found that the Volkswagen Caddy was fitted with a false number plate. This registration plate was found to be registered with another Volkswagen Caddy belonging to a Sabelo Menzin Yandu, number 39. Paragraph 39. The bullet core that caused the injuries to Ms. Malinga was surgically retrieved and sent for forensic analysis. It was identified by Warrant Officer Impo Winnie Josephina Manamela, number 41, as part of a 7.62 caliber, that is an AK-47 rifle. Paragraph 40. Nompumelelo Carol Makatini, number 38, is the former girlfriend of accused number 1. And she confirms that she was in telephonic contact with accused 1 the night of the incident. She further pointed him out in video footage at Morningside Shopping Centre when it was shown to her. Paragraph 41. Ms. Tobijani made another statement after the incident in which she pointed out that she and accused number 3 were in a relationship sometime before the incident, but that it came to an acrimonious end. She further alleges that she knew incriminating information which could give accused number 3 a motive to kill her. She further states that accused number 4 may also have a motive to do her harm. Paragraph 42. Two analysts, Colonel Brown and Karen Barras, did an analysis of the cell phones and cell phone numbers belonging to accused number 1 and 2 and places them at the Grand during the time Ms. Tobijani and her friends were there, as well as at Morningside Shopping Centre later that day. Paragraph 43. On the 1st of April 2024, accused number 1 was arrested in an unrelated matter. During his arrest, his cell phone was seized. On the 21st of November 2024, Sergeant Mbele, number 48, booked this phone out from SAP 13 store and handed it over to Colonel Chesi for downloading. I need to just add here, my lord, that the state will present evidence here that Sergeant Mbele also applied then for a search warrant in terms of the Cyber Crimes Act before the downloading commenced. The downloads revealed, amongst other things, communications between accused 1 and 2 the day before the incident as well as on the day of the incident. On the 16th of October 2023, the day before the incident, there was WhatsApp communication between accused number 1 and 2 making reference to the Grand. Paragraph 45. Also on the same day, at 16:27:05, accused number 2 sent a WhatsApp message to accused number 1 that reads as follows. We're going to follow her out and work Spoke to Majosi, we good. Paragraph 46. At 16:29:51, accused 2 send a WhatsApp message to accused number 1 that reads as follows. What car will you be using tomorrow? To which accused number 2 answered, VW. Paragraph 47. At 16:39:03, accused 2 send another message to accused number 1 that translated from slang reads as follows. I wish the matter regarding Tobijani works out. Aish. Accused number 1 responds, Aish, that's me too. Paragraph 48. Further communication on 17 October indicates that accused 1 and 2 were at the Grand at the same time as Tobijani was there. Paragraph 49. Accused 1 and 2 were arrested on the 24th of April and 17 May respectively in this matter. They appeared in court from time to time. The matter was unfortunately withdrawn at some stage due to a delay in the investigation. Paragraph 50. In March 2025, they were placed back on the roll by way of a J175 summons. They are therefore on warning in this matter but in custody on another matter. Paragraph 51. On 14 May 2025, accused 3 was arrested. 52. His bail application commenced in September 2025. This date is significant, which will become apparent in the discussion of the money laundering and fraud charges below. Under the heading then, the Tobijani incident relating to the money laundering and fraud charges, count 15 to 18, paragraph 53. On the 12th of October 2023, 5 days before the shooting, 20,000 rand is transferred from the FNB business account of Cat Protection Security, that is accused number 3's company, into the FNB account of accused number 5. She is accused number 2's daughter. And the only director of this company is, and I'll spell that for the record, Matlala Construction and Projects. It's LWANDLELWAKHE. Paragraph 54. 15,000 rand is then transferred from this account into the FNB account of a company of which accused 2 is the only director, and that is Malswandile Holdings. I'll spell that also for the record. It's MALZWENDILE. Paragraph 55. On that day, accused 2 sent a voice note to accused 1 saying the following. My man, and it still need hay, Ish Musa, why do we not have any work in hand like this, my brother? Let me call Cat, you know, and I ask him, maybe we can force to do something that me, you and Malankani can do together so that you are able to buy that car. Paragraph 56. In the early hours of 18 October 2023, the mother of accused number 2 and grandmother of accused number 5 passed away. The importance of this will become apparent here under. Paragraph 57. On the same day, a further 100,000 rand is paid over into the company account of accused 2's daughter, and in the exact same way as before. Later that day, 50,000 rand is paid over into the account of accused 2. The reference appearing on the bank statements in both instances is Medicare 24. Paragraph 58. On the 20th of May 2025, 5 days after the arrest of accused 3 and some 18 months after the passing of the mother, accused 4 proceeded to the funeral parlour, which handled the funeral for accused 2's mother, and collected a receipt for 70,000 rand. Peter Koko, number 50, is the owner of this funeral parlour, and Rocky Tong Chabaleng, number 49, is his secretary. Mr. Koko will testify that he instructed Mr. Chabaleng to create this receipt, but he said that he did so under duress and because of phone calls he received prior to this date. Paragraph 59. What is of importance, further importance, is that this receipt was created in a 2025 receipt book and can be found between the dates 16 and 19 May 2025. The date on the receipt was backdated to 26 October 2023. It is expected that the version of accused 2, 3 and 5 will be that the 120,000 rand was a contribution for the medical and funeral expenses of accused 2's mother. Lastly, the Mokobung incident, count 19 to 25, starting there from paragraph 61. On the 29th of January 2024, Austin Sinki Mokobung, aka Gigi Rekis, number 74, and his friends Leonard Pulte Masongu, number 75, and Swarere Tsupise, number 76, were at Brian Maestro. Paragraph 62. They left at around 22:30. Mr. Mokobung was at that stage aware of a white Hyundai parked nearby. Paragraph 63. As they were driving along to their destination, about 1 kilometer from Brian Maestro, the I-20 was still following them. Paragraph 64. As they were approaching a traffic light, the occupants of the I-20 started shooting at them. Paragraph 65. Not far from where the shooting started, Mr. Masongu, who was the driver, had to bring the car to a standstill because he was wounded. Paragraph 66. Mr. Mokobung then jumped out of the car and tried to escape. 67. Two shooters followed him. He tripped and fell, and they started shooting. Paragraph 66. Mr. Mokobung and his two friends were seriously wounded and was rushed to hospital when help arrived. Paragraph 69. Mr. Mokobung will testify that the police never came to take a statement from him. Paragraph 70. He decided to appoint a private investigator to establish who was behind the shooting. Paragraph 71. As a result of what the private investigator conveyed to him, he approached another acquaintance, Mr. Mufuni Zechariah Mutusi Shungwani, number 79, to arrange a meeting with accused number 3, who he knew before. Paragraph 72. In April 2024, the meeting took place, and accused number 3 explained to him that as, and my lord, I don't know what I wrote there, but I'll try and paraphrase. Explained to him that he is one of the associates of Joseph and Yoni. He will remain as long, that's right, as long as he associates himself with Joseph and Yoni, he will remain a threat to Muswati, and his life will be in danger. So that should be as long. Correct that. Paragraph 73. A further meeting took place sometime after his first meeting, during which accused number 3 and him had a conversation regarding the attempts on the lives of Tebogo Tobojane and Joseph Anyoni. Paragraph 74. The following is further significant. On the 24th of January 2024, 5 days before the incident, 5 days before the attack on Mr. Mokobung, 10,000 rand was paid over from the business account of accused number 3 to the business account of accused number 5, who in turn paid 4,500 rand over into the business account of accused number 2 in the same fashion as described in the Dobiyani incident. What is significant here, my lord, again, it was only going from one FNB account to the other FNB account to a third FNB account. Paragraph 75. From an analysis of the cell phone data of accused number 1 and 2, their cell phones are placed near Brian Maestro and near the scene of crime on the 29th of January 2024. Paragraph 76. Further, one of the firearms seized at the residence of accused number 1 was also ballistically linked to the crime scene relevant here. Paragraph 77. Significantly, the original police docket curiously disappeared after the incident. When the current team tried to trace the docket because of the firearm linkages with the crime scene, that docket was nowhere to be found, and they had to reconstruct the docket. It was only then, in June 2025, that statements from the complainants were obtained. Now, finally, my lord, I'm going to refer to the arrest of accused number 1 and 2 because it is quite relevant. Paragraph 78. Accused 1 and 2 were arrested on the 17th of April 2025 by Captain Pini Alfred Sekobela, number 86 on the list, and Captain Thomas Tutetsi, number 87, with the assistance of Christian Frederick Shepard, number 88, from a private security company. Paragraph 79. This arrest led the police to accused number 1's address at number 34Q, 5th Road in Q, Ramley, where a white Hyundai i20 was discovered with 3 firearms in a carry bag behind the driver's seat. The 3 firearms were 1 AK-47 and 2 pistols. and one of which the serial number was scratched out. This pistol was forensically linked to the crime scene in the Mokibung incident. As already stated, the AK-47 was forensically linked to the crime scene in the Sabanyoni incident. Accused one's fingerprints were also found on the white Hyundai i20. My Lord, for ease of reference, I've attached here a little chart that was compiled, just showing what was seized on the day in Granley and how it is linked to the two crime scenes. Well, that concludes the summary of the case. Of course, I don't believe that it is a complete summary, but at least it's an outline.
Right, the accused, we've done the plea proceedings, you've pleaded to the charges, I've had the submissions by counsel, and the state has now read the 150 address. I just want to move on to the next aspect of this matter, where I just want to explain certain matters to you before we start with the evidence. So you would have noted that in respect of the charges of attempted murder, and I'm speaking to those accused, you know which of you have been charged with attempted murder, it's accused number 1, 2, and 3. The state has preferred to charge you with the crimes of attempted murder read together with the provisions of section 51, subsection 1 of Act 105 of 1997, which prescribes in the ordinary course of business the imposition of life imprisonment unless there are truly seen to be substantial and compelling circumstances that may cause a court to deviate in the imposition of the prescribed minimum sentence of life imprisonment. Then you will find that in terms of the illegal possession of prohibited firearm, the prescribed sentence is one of 25 years in the event that you are convicted. Illegal possession of ammunition, the state has preferred to charge you together with the provisions of section 51, subsection 2 of Act 105 of 1997, which prescribes in the ordinary course of business a minimum sentence of 15 years imprisonment unless there are truly seen to be substantial and compelling circumstances that may cause a court to deviate in the imposition of the prescribed minimum sentence of 15 years imprisonment. Then, essentially, the state has indicated the penalty provisions to the accused persons at the time of you pleading. Now, the court believes that it's important and imperative that it explains to you right at the outset of the proceedings the implications that can come your way in the event of a conviction. So what I want to do is be mindful of the fact that from this point onwards, when the state is leading its evidence, it is going to argue at the end of the day that in the event that accused persons are convicted, that the court must now proceed to apply the provisions of the Minimum Sentences Act as well. Now, to that extent, I want to invite the accused persons that I do not want you to sit in the accused dock, relax there, and contemplate life. I want you to take an active part in your defense during the course of this trial. To that extent, what I'm going to do and what I will allow is allow each and every single accused person to be provided with writing material so that whilst the evidence of the witness is being tendered, you will be able to make notes, and then once your counsel or your legal representative is finished with their cross-examination, I shall grant you a firm and a fair opportunity to speak to your counsel in order to raise the issues that you want to raise. So two things will happen. One, it will obviate the need for you every few moments to put your hand up and to attract the attention of your counsel and disturb your counsel with their chain of thought. Two, it will ensure that at all material times you will have a proper opportunity to put your version to all the witnesses. So it is your trial, it is your duty to ensure that you participate. It doesn't mean that you're the accused and you're sitting out there you're sitting in a movie house and you're just watching what's happening. I want you to please participate at all material times. At any point in time during the course of the trial, if there's something urgent that you need to raise to the court, even if it's before you're given the opportunity, you are more than welcome to raise your hand, attract the attention of the court, and the court will come to your assistance. Remember what the court said at the outset? That we fight jealously to ensure that the accused persons enjoy the right to a fair trial, a right to a speedy trial, the right to adduce and to challenge evidence. So I want you to become included in this particular process, and I'm certain that it will make life easier for everyone. For at the end of the process, when the evidence of the witness is given, I don't want that witness to leave the court where an accused person said, you know, I should have asked him 1, 2, 3, or 4. And the reason simply for that is you are given that opportunity because in the event that you are convicted on a charge or charges, the implications are dire. You are facing in the ordinary course of business life imprisonment on some of the counts, then 15 years imprisonment. So any of these counts that the state has preferred against the accused, the ramifications thereof have far-reaching consequences for the accused. So at all material times during the course of the trial, this is your trial, and we shall work together during the entire trial to ensure that the evidence is placed before the court, as well as to give counsel and yourself the opportunity to be able to challenge such evidence. We also then are going to work towards looking at the times per day and try and get the maximum amount of time in sitting time so that we can progress and try and finalize the matter in the days allocated. Accused number 1, can I ask you, are you comfortable thus far from the time that we started up until now? Is there anything that you'd like to indicate to the court, anything that you want assistance with, or are you comfortable? You're happy? Excellent, thank you. Accused number 2, sir, are you comfortable? Are you happy with the proceedings thus far? Is there anything that you'd like to add?
No, at this moment.
You comfortable? Excellent. Accused number 3, sir, are you comfortable thus far with the proceedings? Excellent, good, thank you so much. Accused number 4, are you comfortable thus far with the proceedings? Lovely, thank you so much. You may take a seat. Accused number 5, are you comfortable?
Yes, I am.
Good. And you do understand and appreciate what the court has explained to you at all material times. Do not be afraid to put your hand up in the event that you cannot wait for your counsel to finish, okay? And whatever challenges you may have, please bring it to the attention of the court, because it is the duty of the court to ensure that both the parties before it are treated fairly, and that both the parties before the court, their rights are not being trampled upon. Good. Mr. Gissing, is there anything that you'd like to say before we leave the preliminary proceedings?
Nothing, thank you.
Are you sure?
Yes.
Good, thank you so much. Mr. Khove, is there anything that you'd like to say?
My Lord, no, except that I would request, if possible, that we can have a few minutes to consult with the accused in court once the court has adjourned,
Okay.
just to speed up proceedings.
Excellent, okay. I think what we'll do is, on a daily basis in the afternoon before we take the adjournment, I think I'll give you an opportunity, whilst the court is making his notes, to be able to approach the accused and to have a chat to them so that you can plan for the next day.
Thank you, my Lord. I'm indebted.
Good. Just give me 1 second. Ms. van der Heever.
My Lord, may it please the court. Safe to at this point make the following remark. I've noticed that my learned friend's address to you under section 150 exceeds what is permissible under section 150. I will consider my position pertaining to that this afternoon after we have the court have adjourned. For the rest, I've got nothing else to add. May it please the court.
Thank you so much. Mr. Chowkesa?
I've got nothing to add. Thanks.
The accused persons will give you your writing material tomorrow. Is that fine? You want Z15 or P21 paper? Which one you want? Good, excellent. Right, Mr. Little, are we at the juncture now where you'll be in a position now to start calling your witnesses? Am I right? We've done all the preliminary issues, all have been settled, we are all one big happy family now?
I wouldn't go that far.
Are we in agreement and we're going to take the adjournment for the day? Yes. Excellent. The accused may rise. Thank you. Am I correct in saying that accused number 4 and 5 are on bail?
Indeed so, my lord.
All right. Ladies and gentlemen, we have completed the pre-proceedings, which now brings us to the point where we are ready to commence the evidence. In the circumstances, by agreement, your matter will be postponed back to the High Court of South Africa, Gauteng Division, Johannesburg, sitting here at the High Court Johannesburg, Court number 4E, to Tuesday, the 21st day of July, 2026, at 09 hours 30 or soon thereafter, as the matter shall be heard. Accused number 1, 2, and 3, gentlemen, you are in custody. You shall remain in custody until tomorrow. Accused number 4 and 5, you are on bail. Your bail is extended until tomorrow, the 21st of July 2026. The court has indicated 9:30 or soon thereafter the matter shall be heard to ensure that the parties are generally here and you are ready to commence at 10 o'clock. So for those counsel that are stressed that I said 9:30, we will start at 10 o'clock in the morning, but 9:30 to make sure the members of the media are here on time and that we are not disrupted before we are starting. Good. Thank you to the accused. We shall see you tomorrow. Thank you so much, counsel. We shall see you tomorrow. Mr. Kobe, you want to speak to your clients? I'll wait for you for a few moments. Or can we adjourn and we'll still speak to you?
Yes, thank you, my
Who's
lord.
in charge? Who's in charge of removing the accused persons from court? Can you please just do me a favor? Can you please allow the legal representatives a few moments just to have a discussion with the clients, because we're starting the evidence tomorrow and they'd like to obviously know where we're heading to in respect to the matter. Good. Thank you so much. Then the court, having no further order of business, is going to take the adjournment. Thank you.
We need to make sure all the cameras and recording devices are off.
Ek het die ander dag weer, die jongste hier nie, hier het ek iemand geskreeu in hoor.
The court will then take the adjournment.
Kort termyn ons besig is met die konsultasie. Dus ek sê hulle sal dit hier doen ons dan probeer.
See you tomorrow.